John Adams has stated that the government is instituted for the common good for the protection, safety, prosperity, and happiness of the people. But how can this be so when the government has implicated technologies that restrict our privacy? Because of the evolution of technology, as Americans we must stand up for our individual rights by putting the government to its task. Over the years, cases have taken place that have tested how well our government protects our rights. In Katz v. United States, Charles Katz was suspected of being connected with legal gamblers and transmitting the information through telephone booth. FBI agents became aware of the situation and moved quickly to place recording devices outside of the telephone booth. The recordings of the conversation were used to file a suit against him, and he was taken to trial. When in trial, Katz claimed that the agents could not use the evidence because they did not have a warrant when recording him. The court ruled that although the recordings did show clear evidence of him being involved in legal gambling, the agents had violated the Fourth Amendment that protected Katz's rights to privacy. This case is memorable as it has laid out the foundation for cases that have followed it by using the Katz test. Mr. was convicted of growing marijuana in his private home. Before being taken to trial, the police were informed that he was growing cannabis in his backyard. They attempted to investigate his home beforehand, but had no success because his property was surrounded by a fence. The police took extreme measures and flew above his yard in a plane. By doing this, they were able to gather the evidence that he was in fact growing legal marijuana. The police then obtained a warrant and seized the marijuana. When in court, Cirillo was found guilty, but the court ruled that the search had violated and went against the Fourth Amendment because the police did not have a warrant when searching his home beforehand.
In United States v. Jones, the police installed a tracking device without a valid warrant. The Supreme Court had ruled that the police's use of GPS tracking was a search and violated Jones's reasonable expectation of privacy. All 9 justices agreed that a search had been taken place. Justice Antonin Scalia stated in the majority opinion that there was a physical trespass since the police had to walk in Jones's driveway when they put the device on the bottom of the car, since they physically seized the car when placing this device. In Riley v. California, the court unanimously held that the warrantless search and seizure of digital contents of a cell phone was unconstitutional. A traffic stop resulted in a discovery of firearms. They proceeded to look through this man's phone, and because of this, he was charged with a shooting that was unrelated to this search. Chief Justice Roberts invoked an inspiring story that the police cannot search cell phones when they arrest someone. Generally, the court has held that when arrested, cops can pat down and open closed containers from the body. It was concluded that a cell phone is an intimate product, and since it is so invasive, a search warrant is necessary.
In Carpenter v. United States, Carpenter along with 4 individuals were arrested because they had a connection with armed robberies. Carpenter decided to give their cell phone numbers to the FBI. The FBI took advantage and obtained transactional records. The transactional records that were obtained by the government contains the date and time the calls were taking place and the location from where they called. The government decided to charge Timothy Carpenter with robbery because it affected interstate commerce. Carpenter then argued that the cell site evidence that was used by the government was against the Fourth Amendment because the FBI needed a warrant in order for them to get the records. The court agreed that the government violates the Fourth Amendment by accessing historical records, including locations of cell phones, without a search warrant.
As the people of America, we have the right to liberty because this is a fundamental principle the Founding Fathers have fought for. There is an importance in privacy, and it is just offensive to the people and democracy itself. To allow the government that much power will lead them to annihilate the sacred human right. Cases that implicate the people's privacy threaten the legitimacy of law enforcement. We understand that when it comes to social media and new technologies that are evolving, federal agencies have taken action in obtaining private information from individuals.
Past cases have laid out the foundation for cases now and how the court should rule regarding the constitutionality. In 2015, we remember a terrorist attack that consisted of a mass shooting in San Bernardino that resulted in the FBI wanting to gain access over the Apple device being used. This battle between Apple and the FBI resulted in the company declining to help the agency. It was unjust to many Apple users because this assistance could lead the FBI to do the same thing to many others. In occasions that there is no acknowledgement in a search being done, the legitimacy of law enforcement is being put in question, mainly because these encryptions are a key factor in protecting a user's data.
In light of new technologies that are evolving, the Fourth Amendment must be interpreted in a more progressive manner. Allowing the government too much power can lead to a restraint on civil liberties. We must stand up for equality and privacy in the digital age. At the end of the day, the Constitution has been placed for the people, by the people, and we must acknowledge that
we are the people!